Hello and welcome to In Great Company, the platform where we have impactful conversations with thought leaders to bring you advice, experience, tools that you can use to help you thrive in business. My name is Ramona. I'm a CPA and the founder of Fabric, an accounting practice servicing businesses in the technology and general service spaces. I am so happy to be joined by Josh Joel from Stanton Law and the host of the Stanton Law Podcast. Super excited to talk to you about employment law. Yes, how can you get excited about that, right? We can. I know Josh and I can, right, Josh?
Oh yeah, absolutely. Employment is exciting for me, certainly, especially when I can help solve people's problems.
Exactly. Plus, if you have to talk about this topic with your advisors, it means that you are growing. Your business is thriving, you are employing staff, your staff is growing, and you have issues maybe that you want to address proactively. So, always good to see that we need advisors, that we need technology, that we need tools, because that means that we are growing. So, welcome, Josh. I am so happy that you came to our show today and that you have all this knowledge to share with us. I am looking forward to learning so much from you today. So, get ready. We have a lot to cover. Thank you so much. And please tell us a little bit about you, your career, and the business, how you help small business owners to really navigate through all these employment laws that we see changing from time to time, but also that we have to keep compliant with.
Sure. Well, and thank you so much for having me today, Ramona. And I'm really pleased to be here because, as you know, you and I kind of share a passion for helping small businesses, entrepreneurs, and startups really build out their businesses in a way that they don't have to be concerned or worried. From me, legal issues, and for you, financial issues. And so we share that shared passion. And while we do different things, we certainly work in the same space. And it's really exciting for me to be here with you to talk about this and to talk about what I do. So I'm here in Atlanta, Georgia, down south. So I know that's kind of out of town for you folks up there. That's that little space between New York and Miami. We're kind of in the middle. And I work for a small firm. We have about 14 lawyers here, and we are passionate about helping small businesses and entrepreneurs make their lives better and not worry about legal problems. I'm an employment lawyer primarily, and the other attorneys in my firm can pretty much do anything for a small business from soup to nuts and everything in between, beginning to end. And so I'm excited to be here. I've been doing employment law for 6-7 years. I come from a big law, big firm kind of pedigree and background. And that's where I come from. And I try to use those skills to really help the smaller businesses resolve their legal issues in a way that's a little more business-minded, business-oriented, practical, pragmatic, and not your average attorney, just similar to the way that you approach your clients as well. So I'm really excited to be here.
Thank you. And I'm glad you brought that up because I usually say something that I admire and like about my guests. And one of the things that I really like about you is, besides the fact that you are an expert in your field and that you know what you're doing, I noticed that you are very responsive. You stay on top of your emails, which is sometimes a challenge nowadays. But yes, the approach that you have to client service and to business development and to staying on top of what you do and all these changes is really, to me, something that all providers, service providers, and partners and advisors should have, but it's not something that we find every day. And everything that we do as business owners impacts not only our companies, but the way we service our clients. So I really admire that of you, and that's why we're here today together.
Thank you. And responsiveness is the key. I mean, the reality is that most business owners, they don't want to have to wait around. They want their problems to be solved. They want them solved quickly and easily and efficiently. And if we're not responsive to them, then what's the point? And I'm very that's a big passion of mine, to stay on top of things and make sure that we are there for our people.
Thank you. And there is something you mentioned originally that at the beginning that I thought I wanted to highlight, and it's related to the firm that you work with. I think it's important when we find an advisor that they cover or their firm covers multiple areas within business that might uh, impact us somehow. So in your case, although your specialization is in employment law, your partners in the company can help in other areas of law. So I think it's something that as business owners sometimes we miss. We say, okay, I need an employment law attorney, and we go and find someone who just does employment law, and then later we need someone who can help us with setting up our options agreement or fundraise, and then we don't have that at the moment, and we have to go and search for another firm. Great. So, Josh, I know
Yeah.
this. Oh, go ahead.
Yeah, no. So it's 100%. It's trying to provide the full service and the full gamut of everything that a client needs, so that like you mentioned, when you develop a relationship with a trusted advisor, you want to be able to have a trusted advisory relationship that can cover all your needs. And therefore, while I might do employment law, the small business owner doesn't necessarily make that distinction, and they want to have the relationship with me, and therefore ask me their questions on any area of law that's important to them, and I have to be able to provide that service in a more holistic way for the entire business. And that's very important, especially for the smaller business owners. We can't be cabined into one area of law or one area of practice. We really have to have expertise in a lot of different areas.
Agree. Thank you for that, Josh. So let's go back to employment law. One, as a CPA, I do get questions around other services that my business owners might need, and employment law comes up as one of the first ones, except for maybe options agreements or fundraising. But one of the questions that comes up is, when is the right time? When do I need to hire an employment attorney? Some business owners will say, I just have one employee. Do I have to bother with this now? Do I incur the extra expense at this moment? What do you recommend for someone who is just making their first hire or the second hire in terms of covering these areas so critical to their business?
Yeah, that's a really great question, and it's a question that confronts a lot of people when it comes to attorneys or any business advisor. When is it time to reach out and hire someone or get the help that we need? And I want to emphasize the fact that the most important thing for any small business owner is to start generating revenue. We recognize that your average startup entrepreneur, they just need to generate revenue before they start thinking about the various startup costs that might be at play in developing that business. And so the first thing we tell people is focus on your business, focus on generating revenue, while recognizing that there are issues that come up that if you don't address early in the stages of your development, they're going to be much bigger issues down the road. So outside the employment law context, the most obvious one is going to be the partnership agreements, and making sure that you're set up in a way that your partnerships are set up appropriately, and so that makes a lot of risk go down the road. And so it's worth investing the money early with respect to illegal issues, and recognizing that should be factored into the startup cost of any business. But specifically in the context of employment law, the obvious answer is that you really need to have an employment lawyer on hand when you start hiring employees, right? A lot of people make the mistake of thinking they don't need an employment lawyer until they have a problem. And as soon as you start getting to the stage, and please God, every single small business should get to the stage where they are starting to hire new people and bring people in and scale their business. And the minute that they do that, you've got to have an employment lawyer who can help you navigate those initial issues with the new employees that come in. Because if you don't do it when they come in the door, you can have a lot bigger problems down the road.
I totally agree with that. And it's the same question that I get about CPAs. And
Correct.
it's like, when do I get a new CPA? And I always say, the time might not be right now, but you should know who you go to when you need them, right? So as
Correct.
you grow, as you start needing to file, be compliant with taxes or any financial reporting requirements, do you have someone that you can call and say, okay, I'm ready to move forward? So I think
Correct.
it's important to do your homework and find the right advisors in all areas for your business. And then when you're ready to engage them, then you do. Thank you
Correct.
for that, Josh. What are some of the biggest mistakes small business owners and tech founders or startup founders make in terms of employment law? And I'd love to hear, well, I shouldn't say I love to hear, because that doesn't sound Nice, but I was gonna say I would like to hear some stories.
Yeah,
One
no,
nightmare
100%.
that you have seen happen to someone, because we can learn from all of those mistakes, and I think that is actually the best, one of the more effective ways of learning sometimes.
100%. And you never want to see your clients make mistakes. And for those of us who actually care very deeply about the development of our clients' business, we don't want to see them make those mistakes. And sometimes it hurts to see a client stepping into something, a pitfall that they might not even know is a pitfall before they even get there. And so going back to your question before, and I think they relate very much with one another, is when do you have to get an employment lawyer involved? Well, that relates exactly to the question you just asked me now. The minute you make your first hire, especially in the tech space, especially in the startup space, where your entire value are your relationships, are your client relationships, the intellectual property that you have, your ideas, the things that are the value that you bring to the table. The minute you bring someone new into that business, they're going to have access to and knowledge of the value that your business has, the value proposition, which is oftentimes, depending on the industry, your relationships or your idea. So the very biggest mistake that I have seen startups make is not getting appropriate employment agreements in place from the get-go with enforceable, appropriate restrictive covenants. And a lot of times they say, well, we're just going to go into LegalZoom, or we're going to hodgepodge and nothing wrong with LegalZoom, but not in this context, right? We're going to hodgepodge a bunch of different things we find online together, not recognizing that restrictive covenants, and when I say restrictive covenants, I'm referring to non-competition, non-competes, non-solicit, protection of intellectual property, and confidentiality. Right, those are the primary components. Those four components of restrictive covenants within an employment agreement, and getting those in place is critical, because you can watch millions, literally millions of dollars walk out the door, and you can do nothing about it if you don't invest the $2,000, $2,500 or less to have a good employment lawyer who understands entrepreneurs and startups, put appropriate employment agreements in place with appropriate restrictive covenants that are going to be enforceable under the state law under which you're operating. And that is probably the biggest early stage mistake that we see startups make, is not doing that. And I can tell you war story after war story of situations where, very ambitious, smart, savvy business owners who just want to build their business, they look at the cost of legal services, which it's not very expensive when it comes to the bigger picture of the potential risks involved, the few $1,000s it will spend, and they say, no, I don't want to spend that money on a lawyer. I'd rather just go online and figure something out and be Google lawyer or be my own attorney. And so the point is that that's not appropriate, because I'll give you a war story without giving any specific client information involved in it. And this happens more often than you would imagine. And I have the fortune of being able to see both sides of the equation. Most people come to me after they have a problem or after there's an issue involved. They don't come to me proactively. And I'll tell you, when you come to the lawyer after you already have a problem, it is a hell of a lot more expensive to resolve that problem than when you come to the lawyer proactively to deal with it in the beginning. So example, someone comes to me, this happens probably once a month, once every 2 months. I am either a departing employee or I have an employee departing. Let's go with the departing employee. Right. And I have non-competes or restrictive covenants that don't allow me to do my work. Right. And I want to go and find a way to be able to start a competing business. Well, you give that to an employment lawyer like me. I look at those agreements and I say, well, I can drive a truck through the holes in these agreements. Right. And therefore the leverage that your employer has is very, very small compared to what you think it might be. And so therefore I can tell them, let me speak to the lawyer on the other side. I can have a heart-to-heart, lawyer to lawyer, and say, that your client screwed up, and put non-competes in place that are not necessarily going to be enforceable. We can fight over this for the next 3 years. It's going to cost your client hundreds of thousands of dollars. It's going to cost my client hundreds of thousands of dollars. And I'm not joking about those costs. Or let's figure out, you've lost your leverage in this negotiation. Let's figure out a way for this person to leave in an appropriate and amicable way where they can get out of their covenants. I can't tell you that how many times I've helped people do that, because that startup, that the employer did not take the time or money to invest in creating, locking down enforceable covenants that they can make sure that their employees are not going to steal their information, steal their clients, or steal their ideas on their way out the door. And so flipping that to the other side, which is the people I typically represent, which is the business owners, I often tell them it is I saw someone in the comments mentioned an ounce of prevention is a pound of cure. Absolutely. Spending the $2,000 or $2,250 or $2,500, depending on the complexity or more, to put an appropriate restrictive covenant agreement in place, an appropriate employment agreement in place, can save you hundreds of thousands of dollars in legal fees down the road, but more importantly, millions of dollars of revenue lost if you are not able to enforce your agreements when your employees leave your company and go somewhere else. And so that is I think is the very first mistake that I see a lot of startups make, is really playing Google lawyer on things that are very complex. Restrictive covenants are developing. It's very controversial. It's very complex. Every state is different. And to have a lawyer come in and really help you unpack how to make those best to leverage yourself and protect your interests before you even hire someone as they come in the door, that is absolutely key.
Oh my gosh, I love everything you said, because I have seen so much of this happening where I see engagement offer letters that are too short. Sometimes they don't cover anything that is I know that we need to comply with, in the case of any issues later on legally. But also the NDAs, the non-compete, the non-disclosure agreements that sometimes are paired with the offer letters are not or the employment letters, I want to use the right term, they are not comprehensive. And one thing I thought of, and maybe you mentioned this, is that it's also important to ensure that the non-disclosure agreements covers your clients, right? So you don't want employees to also make some private information about your clients public, right? So can you also talk about that a little bit, Josh?
Sure. So that's a great point. And let's be clear here for 1 second that even outside of the employment agreement, when you hire someone as an employee under every state law, they have what's called a duty of loyalty to their employer. It's kind of like a fiduciary duty that you talk about in the financial world, which is that when you hire an employee as a full-time employee or a part-time employee, they're required to give all of their efforts to you and not to any self-interest or anybody else who might have a competitive interest towards you. So that's number one. And so when it comes to client information, when you have an employee within your company, they also have to act in the best interest of your client, because that's in your best interests. Now, oftentimes when you sign a non-disclosure agreement with a client, in terms of the information that's going to be passed back and forth between you and your clients, right? That non-disclosure agreement will include your employees, that they also have to comply with the non-disclosure obligations that you have with your client. And typically in the employment agreement, the offer letter or the restrictive covenant agreement, it's important to have confidentiality provisions, and they almost all do, that require your employees to maintain your information as confidential and your client's information as confidential as an extension of that. And confidential information has to be defined and has to be clear what is considered confidential in order to be able to enforce that both during their employment, and you can also enforce that after they leave. After they leave, they cannot take your confidential information or your trade secrets, your client's confidential information or their trade secrets, and go use that to compete unfairly in the marketplace.
Yes. Thank you, Josh. And what are some of the main things that we should take into account from an employment law perspective at the federal level? You mentioned 4 items that we should include in our employment agreements with the employees, but is there anything else that is major these days, especially since COVID, anything that has changed that we must become aware now? Because for many years we have taken some things for granted. Employment is at will. We have to pay fair salaries. They're exempt and non-exempt employees. But things change, and I know they change in the world of tax laws all the time. So any major issues today that we should be aware of?
Yeah, 100%. So this is a complicated question, but I'm going to try to simplify it as much as possible. A lot of it depends on the size of the employer. Right. So the demarcation line, which is important to know, is the key number. Never forget this number when it comes to employment law, is 15. OK, If you have 15 or more employees, you are going to be hoisted onto you a whole bunch of federal laws with respect to what you have to do with your employees. So 15 or more is when discrimination laws come into play. We're talking about Title VII, which is discrimination based upon race, gender, religion, all these different protected classes. The ADA, disability requirements, disability law, pregnancy discrimination, all the discrimination laws really kick in. Those are the federal laws kick in when you have 15 or more employees. When you have 50 or more employees, that's another threshold to be aware of. That's when you start talking about potentially FMLA, which is federal leave requirements and things like that. But I'm going to assume for a minute, let's talk about 15 minus, because we're talking about entrepreneurs. A lot of folks, it takes a while for them to get above the 15 employee threshold. The biggest mistake when it comes to federal law, and again, there's a whole host of state laws, and every state is different, and definitely check your state laws. I know in New York and New Jersey, there's a whole lot more than here in Georgia, where essentially you can do whatever. There's very few employment laws that are on employers here in Georgia. In New York, you have the New York Human Rights Act, other things like that. That certainly are important to take into consideration. But when it comes to federal law, the most important thing to consider is wage and hour rules. The Fair Labor Standards Act, which is a rule that requires you to pay minimum wage and requires you to pay overtime. One of the biggest mistakes that employees make, and it's important to employers make when it comes to federal law, is hiring, quote, 1099 employees. That is a misnomer. There's no such thing. Right? You're either hiring 1099 independent contractors or you're hiring W-2 employees. There's no such thing as a 1099 employee. It is very complicated under federal law what it is what defines an employee versus an independent contractor. And a lot of startups think that we can just pay them 1099, right, and pay them with and not do the withholdings, and then we're covered. We don't have to worry about paying overtime. We don't have to worry about liabilities that we have with them doing stuff we don't like. We don't. And then, but the reality is that whatever you want to call it, it is not. It doesn't matter. Right. Under federal law, the definition of employee versus independent contractor is a legal issue. And what does it boil down to? It's a very complicated situation, but control. If you control the means and methods by which that employee does the work that they do, that person does the work what they do, they are not a 1099 quote employee. They have to be paid W-2, right? And you have to pay them overtime, minimum wage, assuming that they're non-exempt, right? And that is a critical issue that is a big problem that a lot of people fall into, misclassifying their employees with respect to 1099 versus W-2, misclassifying independent contractors as independent contractors, not employees. And when do they find out that this is a problem? Very simply, when they get a knock on the door from the Department of Labor, right, with an audit or something like that, or when they have a problematic employee who's looking for issues and finds out this is an issue, and they register a complaint with Department of Labor, and then you end up with an investigation on your hands. Or worse, when you have a plaintiff's lawyer, right, come in and say, you're not paying your people appropriately, you're not paying your people properly, and then you have a really serious problem on your hands. And so I would say from a federal standpoint, that is the key issue to take into consideration if you're less than 15 employees. Once you're over 15 employees, then you have to really start thinking about employee handbooks, which you should have earlier than that as well, and making sure that your discrimination, harassment, sexual harassment, disability, and other kinds of policies are in place. Again, but that usually comes a little bit down the road for most startups.
Great points. And the 1099 issue comes up all the time.
Correct.
Anytime I have a meeting with a client that says to me, my employees are 1099s, or I have a 1099 employee, I hired a 1099 employee, I correct them and say, let's never say that if they're truly 1099. But and a lot of business owners are trying, or that model makes sense for their businesses, where 1099 contractors is the way to go.
Right.
But it's important that they're aware of what is the clear distinction, and that they follow all the rules, the guidelines by the Department of Labor and also by the IRS, because we have guidelines that restrict who is an employee who is a 1099. And it's important to really separate the language so there is no confusion. You mentioned 2 examples of how this can come back to haunt us. And another one that I hear sometimes is when a 1099 contractor goes to file for unemployment, and
Correct.
they say, oh, my employer is XYZ, but that wasn't really their employer. That was just a company that they were doing contract work for. But that's another situation where this can come up as an issue.
Correct. That's 100%. And
Great.
so, I would just say, just to add to that, the point that you're making is really, really important. Like you said, these are complex issues, and there's nothing wrong with having independent contractors. In fact, very often it is beneficial for the startup or the entrepreneur to have independent contractors doing the work that they need to be doing. But you have to make sure that they really are independent contractors and making sure that you're not exerting control over the means and methods by which they're doing their work. So, for example, if you're making them wear a uniform, if you're controlling the times, hours that they come to work, if you are telling them how to do their work, if you're paying them hourly, if you have non-competes and restrictive covenants, all these things where you are showing more and more control over the day-to-day activities that they have, it's much more likely that they're going to be considered employees. So going back again to your first question, when to get an employment lawyer involved, oftentimes I'm counseling people on how to set up independent contractor relationships or independent contractor agreements so that they don't run into the pitfall of them being misclassified and having a very, very expensive legal battle ahead. Because just to give you a sense, under the Fair Labor Standards Act, if you don't pay someone overtime or you misclassify them, you're looking at paying all the back pay times 2 plus their legal fees plus your own, right? And that's a scary thing and can be very, very expensive.
Yes, totally agree. And we don't want that. We don't want to spend more money than we need to. Remember that bottom line. That's what we're in business for.
That's exactly right.
Yes, don't give money to penalties, to late filings, to more legal services than you need just to prevent issues. So let's be proactive in avoiding some of those mishaps. You mentioned earlier Atlanta, or Georgia, that's where you are, and New York. And each state will have different employment laws also. How can business owners stay, or at least be aware that federal employment laws are one thing, but then we also have to comply with local state employment laws, especially now that we have so many business owners hiring all across the U.S.
Yes, this is a major issue, especially after COVID, where people realize that they can really move to a hybrid work environment and have people working from whenever and wherever. And it's an issue that's developing under the law now. I mean, for example, I've got clients here in Atlanta who are hiring employees out in Utah and Wyoming and these kind of places, which is great for equity. It's great for the ability to spread the wealth across the country and to reach underserved areas. It's a wonderful development. But you have to recognize, here's a good example, right? An issue that a client dealt with recently. If you want to hire an employee, there are federal laws around how to run background checks, right? And what you can and can't do, what is disqualifying, how you run people through the background check process. Well, guess what? There's also state laws about that as well. And if you're not aware of the state laws where you're hiring, you're going to run into problems because more often than not, the states are going to be more restrictive than federal. Federal is pretty easygoing, and so generally, as a general principle, and this is not a political comment, this is a business comment. If you're in the more conservative, more business-friendly environments in the South, for example, Georgia, South Carolina, Florida, these states, you're going to have less state laws to be considering when you're talking about complying with state law. When you're in the more liberal states, especially California, but talking about Illinois and and New York and New Jersey, Connecticut, these kind of places, there's going to be a lot more state law to consider. And as you mentioned, local law. There are even cities that have, and municipalities that have laws on top of the state and the federal law. And so how do you know how to stay compliant with all of this? Hire a lawyer, right? Again, that's why it's important to have an attorney in your Rolodex, to have a good employment lawyer. If you have a good HR person, which a lot of small businesses don't have the time or money to invest in, that's also very, very helpful. But the HR person often doesn't know everything. And anytime you're moving into a new jurisdiction, a new state, a new environment, make sure to do your homework to see what are the laws there, both on the tax side. That's another thing which I'm sure you deal with very often, making sure that you're compliant with the appropriate state taxes, wherever the employees might be, but also when it comes to state laws with respect to employment. I'll just mention while we're here, going back to the first comment about non-competes, restrictive covenants, and confidentiality agreements. Those are all matters of state law, okay? And every state is different. The general principles do apply in almost all states except for California. Even New York, the general principles still apply. But how and when those things are enforceable is going to be fully dependent on the state in which you're operating and the state laws that you're working within. And so, for example, Georgia is pretty typical for most states in the country. New York is actually, believe it or not, similar. You can enforce non-competes and non-solicitation agreements, restrictive covenants, as long as you are protecting a legitimate business interest of your company. But anything beyond the legitimate business interest of your company is not going to be enforceable. That's a general principle. So anytime you're moving into a new jurisdiction, it is certainly important to check with your attorney, check with your trusted advisors to make sure that the non-compete, restrictive covenants, and confidentiality agreements you have, NIP agreements that you have in place, are going to be enforceable appropriately in that jurisdiction as well.
Totally. I mean, that's a great point. And I have seen, in being from New York and having my business here, New York all typically has changes, right, first than before other states. And one of the things that we, not to say, guys, that we go first. Don't get me wrong. It's just that I hear them first. But we have seen, for example, when the federal minimum wage was X, New York State had a different one, and it was higher than what the federal was. And then New York City enacted an increase before the rest of the state did. So definitely be aware of the changes locally and statewide before, in addition to being aware of what's going on at the federal level. And that's where you have a good advisor on the legal side to help you navigate through that. And of course, a good payroll company, payroll provider also.
100%. And I would just mention that you'll find more and more that employment lawyers, specifically like myself, our practices are not geographically limited, because we're living in a new age economy, especially in the realm that you and I work, which we work with a lot of tech startups, a lot of scaling tech companies and scaling companies generally. They are not geographically limited, and they have people, frankly, all over the world who work for them. I mean, I've got clients that have offices in France and Israel. You get clients who have offices out in the Far East, and that's normal in the world that we're living in today, especially in the context of research and development. And so it's important to recognize in that context, for employment lawyers like myself, we are increasingly having to be aware of, knowledgeable of, and able to counsel our clients on laws across the country. And you'll find that most employment lawyers are going to be proficient nationally and be able to work nationally as well.
Thank you. And I know that, you mentioned this before, we must comply with certain requirements when it comes to employee benefits. But I'm of the belief that we don't do just what is minimum when it comes to employee benefits. We want to do a little more than that for retention purposes. What is your opinion on that in terms of doing, or maybe as an attorney, I don't know if you can give your opinion on screen without signing something, but let's just give me your feedback on the difference, your perspective on just doing the minimum on benefits because the federal or state law requires it, or versus doing more than that just for employment retention or employee retention. And I know you are part of a company, so this is something that you probably deal with internally.
100%. And I'll preface that by saying, like you mentioned, nothing I say here is legal advice per se. It's just giving you some direction.
I meant to remind you of that because you say that at the beginning of the presentation.
Yeah. That's the classic lawyer line. We have to say, go seek your own counsel for things that are actual legal advice. I'm not giving legal advice. This is informational only. But anyway, I'm not that kind of lawyer who just checks the boxes. And on your question, it's actually a great point. This leads me to a critical point, and our passion at our law firm as to how we practice law, which is we don't want to make business problems into legal problems, right? And when it comes to employee benefits, ultimately that is going to be a business issue. That is going to be, how are you going to retain and attract the appropriate talent? The reality in the world today, as we're seeing, is that we are in a tight labor market. It is hard to find good employees. It's hard to find people to work. You have stores and restaurants and other places that are closed because they simply cannot find anybody to work. It's an amazing thing, right? So when it comes to benefits, that goes to culture. Like you said, it's so important to recognize that the workplace is not about just complying with the bare minimum of federal law or state law or any of these things like that. If you do that, you're going to have a really awful workplace, right? Going back to the discrimination conversation, right? Yes, according to federal law, you don't have to have, you are not covered by the discrimination laws. Some states, by the way, are a little different until you're 15 plus employees. That does not mean that it's okay to sexually harass your workers, right? It's not just about the law. It's about creating a safe work environment, creating a optimal work environment, creating an environment where people love coming to work every day and are happy to come to work every day. That's what it's all about at the end of the day. So when it comes to benefits, yes, there are federal laws and state laws about what you should and shouldn't do in terms of leave, parental leave, medical leave, health insurance, all these different things it's all true. But at the end of the day, the bottom line is that if you are trying to attract really good talent to your business, you want to put in place a really good benefits program that will attract that talent. And so I believe that the private market does allow for a advancement in this area. For a great example is paternity leave, right? Many people don't give paternity leave, right? But and most states do not require you to give paternity leave. But you know how happy that's going to make your employers if they know they can take some time after they have a baby, even the men, right? Maternity leave, it's the same thing. Many states, you do not have to provide maternity leave. All these different things are areas that boil down to creating an environment where you can attract the best possible people to work for you, and don't just comply with the law. You should go above and beyond and find a way to create a really, really healthy work environment.
As a
Sorry, it's a
mother,
passion point of mine.
I see. No, I love it. As a mother of two, I would have loved for paternity leave to exist when I have my kids. Oh my God, I could have used so much help, and
As
that would have
a,
made me happy.
as a father of five, I would have loved to have paternity leave too.
Five, okay, you heard it. We are
Got you beat.
parents too. We are parents too. In addition to running businesses and helping you all grow yours.
That's
So
right.
I love it. Um, Tell me a little bit about your podcast. I want our listener to know about it so that we can check
Sure.
it out.
Yeah, certainly. So I manage and I host the Stanton Law Podcast, and my goal is really to interview and bring business leaders on to talk about issues that are valuable to small business owners, entrepreneurs, and scaling businesses. But most importantly, I love people to come on and share their stories and how their personal lives and their personal passions and who they are as people has informed and created who their business is and the way they practice whatever it is that they do. And so that's the podcast that you can find it on Spotify and all the other different channels. And I have fun with it, and I get to meet interesting people and learn about people's lives. And it's just a meaningful thing to be able to learn about what makes people tick and how that, because I don't believe in work-life balance. I believe that we should have integrated lives, that our business reflects our passions, that our passions reflect in our business. And therefore that's what I like to showcase on the show, and be an opportunity to showcase different kinds of businesses and leaders and how they operate. So it's kind of fun.
You see, Josh is not your typical lawyer. He's
No,
not.
no, nope.
Thank you for sharing that, and we'll share the links to all of Josh's social media platforms and the podcast, so you can check that out at some
Certainly.
point. And yes, and I can't wait to. Yeah, I'm gonna put you in spot. I can't wait to be a guest on your podcast. It's just not an
You're coming,
exchange.
right? A few weeks.
I am. I am. It's coming. It's coming
Yep.
up soon. Thank you so much. I really enjoy this conversation. I am learning so much. I think we can talk about employment law forever, and you do this day in and day out, and you help so many business owners. And I will definitely have you back next year for some new topic. And I really appreciate you joining us and giving us so much information.
Well, I appreciate you having me, and it's always a pleasure to share the wealth. And like I said, at the end of the day, I care about small business owners. I care about entrepreneurs. I really do care. Maybe I care too much, and it hurts to see people fall into the pitfalls without necessarily knowing what they're falling into. You don't know what you don't know, and so certainly follow me on LinkedIn, because I post a lot of educational content on there to give people ideas of things they need to consider. And if anybody wants to continue the conversation, I'm more than happy to do so.
Thank you. We really appreciate that. And now I want to tell you, I don't know if you can see our comments, but we have some questions and
Sure.
comments. I want to read this to you, some of them to you. So we have some feedback from Alexis, very engaged and giving us great feedback about the content. Alexis, thank you so much. This is awesome. She says, being a father of five, your life is never going to be boring. I agree.
Nope.
that's, that's why he has the personality that he has, I think. He probably won't
it's
admit
it's
it, but go
it's a
ahead.
coping mechanism.
No, it's kids make life so interesting, right? And when you have more
Yeah,
than one, it's so much fun.
100%.
Yeah. So
Yep.
let me see. Let's see. I think there are some comments around having an NDA and a client and employee agreement is great information. That's from Donna. Thank you, Donna. We appreciate the feedback. And yes, there is a lot of great feedback here, so you can see that later. And I thought there was a question from Donna, but I can't find it now. Let's see. Oh, she had asked, there are some keywords or statements that we can tell her so that she can remember us as she's thinking of us, or of you, maybe. She just said you, but I don't know, maybe it's both of us, so that she can make well qualified introductions. So I think it's the personality. Don't you see this guy? My gosh, like how would you not remember him? But anything else that you want people to remember you for professionally, Josh?
Yeah, yeah, again, Ramon, I think it's very similar to the kind of people that are great introductions for you, which are those, those companies that want to scale, and they want to really build their business and not have to worry about issues. I saw someone mention in the chat the fact that there should be legal packages, for that are outside of just legal Zoom. I'll tell you, a good business-minded attorney. I'm not going to straight out pitch what we do, but there are ways to do that. In other words, I have different things that I provide my folks who do a lot of flat fee work for people like that, who are trying to scale their business, right? And so they want to know what those costs are going to be. So any business owner who is looking to scale, who wants to create a platform upon which to scale, they really need to be considering how to set up their legal compliance so that they don't have to have those concerns, and then they can really scale their business, similar to the kind of people that Ramona works for in a different area. And so any small business owner, any entrepreneur, any kind of tech person in that realm who is starting to hire employees or starting to get involved in scaling their business, those are important people to make introductions to attorneys, not necessarily me, anybody who has a mindset of problem solving, of business, a business-minded approach, proactive thinking. That's really critical, because I do know there are a lot of attorneys out there, as Ramona knows, which is why she brought me on, I guess, who tend to complicate things and tend to make legal problems and business problems into legal problems, and that's just not the way we need to do it. We don't want to complicate people's lives. Getting a good partner, a good trusted advisor, can actually simplify your life and can actually be a whole lot cheaper. So those are the kind of people that I love to talk to, I love to work with.
That's exactly why I brought you to the show. You are right on point.
Yeah, and
Thank you.
I'll plug you, Ramona, because Ramona, there's a reason why we connected, which is that check for anybody who's my connections who are listening, check out Ramona's website. She's awesome, and check out her LinkedIn content, because she very much works in the same spaces, of the same mindset of me, and I love having other partners who do different things who have that similar mindset. So make sure to check out Ramona and follow her on LinkedIn. I know she's not going to plug herself, but I'm going to plug her.
Thank you. Thank you. I appreciate that, Josh. We make a good team, I guess, right?
There you go. Yes.
Thank you so much. Thank you, everyone, for the feedback and the engagement. We really appreciate it. It sounds like this is a topic that is critical and important to a lot of you. You're taking it seriously. So we will take that as a sign or a signal that we must continue to have these conversations. And we'll do that in the next few months. Tune in again every second and fourth Tuesday of the month. You will be getting the posts on social media with the upcoming events and on our newsletters. If you want to sign up for the newsletter, just go to our website, fibric.com, and you'll be able to do that and get included in all our events for the month. Thank you, everyone. Thank you, Josh. Really appreciate you, and looking forward to continuing conversations around
Yep.
employment law.
Thank you for having me. I appreciate it.
You're welcome.
All right. Have a great day.